If you have ever sold a car or you will ever sell a car, you need to watch this video. That's because I did a rather tongue-in-cheek video on TikTok yesterday and it absolutely blew up in the comments with people misunderstanding the law or just not knowing the law full stop. Now, this all came about because I did the video in response to another comment that quite frankly and blatantly said that selling a vehicle that is unroadworthy is not an offence. That was in response to another video that I did, which in the midst of other things that I was saying, I said that to sell a vehicle that is not roadworthy is a criminal offence, which it is. There are various defences available, and that's why you need to watch this video. But the commenter that responded to me just blatantly said it is not an offence to sell a vehicle that is unroadworthy. And so in this video, we're going to go through why that very much is the case. The starting point is it is an offence to sell a vehicle that's going to be used on a road that is not roadworthy. In fact, dealers are prosecuted all the time for this offence. Some of them end up paying hundreds of pounds in fines with a criminal record, and others paying tens of thousands of pounds in fines because it's obviously more extreme. Now, what is an unroadworthy vehicle? Well, this can be a number of different things. It could simply be that the tyres are not within the construction and use regulations, i.e. below the legal limit, or simply bald tyres. So for somebody to sell a vehicle like that is not roadworthy, that is going to be used on a road, is a criminal offence. Why? Because obviously the law wants to protect everybody from unsafe vehicles on the road. Now, before we get too far ahead of ourselves, let's move to the law so you can have a quick look at that. It's contained within Section 75 of the Road Traffic Act 1988. As I said, there are some caveats and defences to this, which we'll go through in this video. But the starting point is that vehicles are not to be sold in an unroadworthy condition or altered so as to be unroadworthy. And that includes selling it, offering to sell it, or supply it. Interestingly enough, the supply has had meaning derived through the court system from drugs cases, exposing for sale. So any of those references include any of those things. Exposing for sale, interestingly, might just include having the vehicle on a sales forecourt, which is offering it for sale. If it is not roadworthy, it should have a sign in there to say that it is clearly not roadworthy. But this doesn't just apply to dealers, it applies to anybody, because it says no person shall supply. Now, a person can be a natural person or a incorporated person. Watch the comment section go crazy with all those freemen of the land types that ask me to define what a person is. A person is either a human person like me or you, or it's an incorporated person, a company. Now, moving to what makes a vehicle unroadworthy. This is set out very broadly in Section 3, subsection 3, which says it's in such a condition that the use of it on a road in that condition would be unlawful by virtue of any provision made by regulations under Section 41 of the Road Traffic Act, as respects the brakes, the steering, the tyres, the construction, the weight, or any equipment on the vehicles, or it's in such a condition that the use on a road would involve a danger of injury to any person. So pretty much anything that is wrong with the vehicle that would make it unroadworthy or is in any way contravening and being unlawful in respect of these regulations, it is an unroadworthy vehicle. Now, of course, this extends to altering a vehicle so that it's rendered the vehicle in such a condition as well. Now, as I said, there are some defences or broad exclusions available within this section. They're under Section 6 and 6A, but the offence is specified here. A person who supplies or alters a vehicle or trailer in contravention of this section or causes or permits it to be so supplied or altered is guilty of an offence. And so not only could you be prosecuted under Section 75 of the Road Traffic Act, but also the General Product Safety Regulations of 2005, which can also attract prison time and a fine or both. Now, moving back to the main defenses here, because all of the comments that exploded on TikTok were largely from those that didn't watch the full video, as if the attention span for circa 1 minute videos is not short enough. They didn't even watch the full video. But halfway through the video, I briefly outlined these sections here, which provide that if it's going to be exported, then a person shall not be convicted of the offence. So this is a defence, really, because the starting point is it's an offence and there's a defence here available. So it shall be a defence. Sometimes it's worded, it shall be a defence, but sometimes it is more strongly worded as a defence. A person shall not be convicted of an offence under this section in respect of supply alteration if he proves that it's going to be exported from Great Britain, or he had reasonable cause. Now, this is the one that most people will rely on, but there is a few caveats to this as well, so keep listening. That he had reasonable cause to believe that the vehicle or trailer would not be used on a road in Great Britain. So quite clearly, if you sell your vehicle for scrap, you have a reasonable cause to believe it's not going to be used on a road. Or if you've sold your vehicle parts and repairs only, then you would have reasonable cause that it's not going to be used on a road. Now, there's a few caveats to that, because if a person comes along and says, would it drive okay, even though you've put a sign on it saying, parts and repairs only, if they ask you the question, and this goes whether you're an individual or a dealer, if they ask you the question, would it drive okay? And your response was, well, yes, it will, but you're not supposed to use it on the road because it's only for spares and whatever. And they wink at you and say, no problem, mate. So you know that they will use it on a road, and then obviously they drive away in it, even though you'd put the signs in and everything else. This may still come back to you for supplying it because you no longer have a reasonable cause. If you know that the person is being dishonest about saying they won't use it on a road, if you know that, that is no longer a reasonable cause, because this is an objective test. Would an ordinary reasonable person with a grasp of the facts at hand believe your sort of defense that you had reasonable cause to believe that they would not use it on a road? If you saw them drive it away, think about that for a moment. You see them drive away, and then you ask a jury to believe that you had reasonable cause to believe they're not going to use it on a road. That doesn't work, does it? So if they tell you, of course I won't use it, I'll just take it home and repair it, well, that's no excuse either, because you've seen them drive away in it. So that does have its own nuances and caveats. Now, in order to cover yourself, whether you're an independent trader, whether you're an individual person, whether you are a reputable dealer or whatever, this is always going to come up if the vehicle is not roadworthy. Now, the question arises with MOTs. As I think about it, we'll come back to that in a moment. So in order to secure yourself as best you possibly can, is to make it absolutely clear to anybody buying it, if it's not roadworthy, that it is only repairs or spares or needs to be repaired before it's used on a road. And so then you could arguably say that you have a reasonable cause to believe that in its current condition, it's not going to be used on a road. Now, that's where we come to the next bit, which is sort of covered in what I've just said, which is 6A. This is in the course of trade or business. So this mainly applies to dealers. So this bit doesn't apply to individuals unless, of course, they are operating in the course of business. You don't need to be a limited company or anything like that, just acting in the course of business. So you can be an individual sole trader, but as long as you're acting in the course of business, this could apply to you. And again, facts will determine whether that is upheld in court. So 6A. Paragraph B of subsection 6, so this bit, the reasonable cause to believe bit, does not apply to a person in the course of trade or business when they expose a vehicle or trailer for sale unless he proves that he took all reasonable steps to ensure that any prospective purchaser would be aware that its use in its current condition on a road in Great Britain would be unlawful. Or, the alternative, offers to sell a vehicle or trailer. So the distinction here is exposes for sale. putting it on the forecourt, or an offer to sell. So you put up an advert, or you face-to-face offer to sell it. Again, unless he proves that he took all reasonable steps to ensure that the person to whom the offer was made was aware of that fact. So you put an advert on Gumtree or eBay or wherever, or any motor trade website. If you make it clear that it is not to be used in its current condition on a road, that would be you proving, so long as it was sufficient, that you've satisfied this section. Now, Gumtree was the interesting one, because that's one. It all took me all of 2 minutes to find at least half a dozen cases where traders have been prosecuted and fined for exactly this. One of whom was an independent trader advertising it on Gumtree, and obviously it was not roadworthy. Now, I said I was going to come back to MOTs. Now, an MOT certificate, which is a legal requirement for you to have your vehicle, to drive your vehicle on a road, you must obviously have a valid MOT certificate. However, your vehicle must also be roadworthy for you to drive it as the driver. It must also be roadworthy for a trader or any person to supply or expose for sale, all of the things that were covered in this section here: to sell, to offer, to sell or supply, and to expose for sale. For any of those things, it must be roadworthy. That is a separate condition from the MOT certificate. The MOT certificate is simply a certificate that it was roadworthy at that moment in time. One of the cases that proved this conclusively was where the MOT certificate was issued, but then part of the suspension collapsed, and therefore it was no longer roadworthy, and yet the vehicle was still supplied back to the customer by the dealer anyway. Now, because it was supplied, and this is where the nuances of the drugs cases came up with the supply of something, the dealer had supplied it to the customer in an unroadworthy condition, despite it just recently having passed an MOT. So having an MOT certificate, which is in date, is not proof that its current condition is roadworthy. It is only proof that it was roadworthy at the time it was tested. The law requires the registered keeper to have a regular MOT safety certificate just to keep the vehicle in a roadworthy condition. And so the obligation is upon you to keep that vehicle in roadworthy condition and to prove as much by having an MOT certificate. I hope that makes sense. So if at the moment in time you supply the vehicle, which is either selling it, offering to sell it or supply it, or exposing it for sale, any of those things, if it is not roadworthy at that moment in time, irrespective of an MOT certificate, you potentially are liable under this section. Although I dare say it would act as some sort of mitigation if you just had a MOT certificate and you believed that it was roadworthy. It doesn't change the strict wording of the offence, in that it is an offence to sell, offer to sell, etc., a vehicle that is not roadworthy. It is strictly worded, but it may act as some sort of mitigation. It may mean, if you are convicted, it may mean either a conditional discharge or a fine of a few £100, as against a fine for £10,000, £12,000, £13,000. Whereas one such trader was indeed fined over £13,000 for supplying a vehicle where the brakes were defective and they didn't work. So I hope that all makes sense. This is the longer version of the very short video I did on TikTok that blew up with all of these sort of debates in the comment section. So in short, yes, you can sell it to scrap, you can sell it for parts, you can sell it for repairs, provided that you make it absolutely clear that that's what the purpose is for. And having a wink from your customer that they're not going to use it as they drive away and you wave them off with it, obviously that is not going to be a defense for you. But I hope that's useful. If it is, please do like the video and subscribe. And as always, thank you for watching.